Good morning, you're Mark Ramirez. Give me just a second. And Mr. Ramirez, this is your initial appearance in cause number 25 DCCR 1362. You're charged with the second-degree felony offense of aggravated assault with a deadly weapon from August 24th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, I talked to one, I forgot his name, I'm bad at names, but they said that they were gonna appoint one.
Speak up, please.
They said they were gonna appoint one because my fiance talked with the DA and with the Keith guy, and something about trying to get a dismissal under recommendation on my behalf, or to see if I could get that person.
Okay, so who's your girlfriend? Is that Patricia Zamora?
Yes, ma'am.
Okay.
She was outside, but they didn't let me.
Okay, you do understand that there's a no contact according to your bond at this time.
It was set by the judge in Jefferson County for last month that it was it was lifted. It was lifted last month.
Who lifted that?
I got the paperwork from the judge.
Well, but regardless of the protective order, there should be a, yeah.
Yes, ma'am, they lifted the protective order.
No, I'm not talking about the protective order. So a condition of your bond is that you not have contact. So there's two different things. There was a protective order that lasted a certain amount of time. That's over, the emergency protective order. However,
So I guess they never told her that either.
well, they don't have to tell her that. It's you. Hold on, I'm looking at some paperwork here. Okay, this is, were you also arrested for driving while intoxicated at some point?
That's my
So the magistration paperwork that's in the aggravated assault case is the DWI paperwork. Let me see. No, because it's got the interlock and May 24th. No, 2 different days.
It happened like in the 2 weeks prior in the same.
Do you have the auto ignition interlock device on your vehicle? Okay, if you'll make a note for Christy, I need the magistration paperwork for, can you just have a seat real quick, guys? I want to see the paperwork just to make sure that all the bond conditions are what they need to be on the correct case. So don't leave the courtroom, just have a seat for a minute. Is she here? Okay. Part of what I usually tell you to do, but what I am going to tell you is you probably can hold off on hiring someone. If everything goes well, you adhere to the bond conditions, she takes the class, then at some point, it looks like your case will probably be disposed of without the necessity of you hiring an attorney. It probably isn't a bad idea for you to start looking at least. And obviously, I understand that you guys, it looks like you're trying to work things out, but you're gonna have to not do that for some short amount of time.
Okay, I've been going through issues, illnesses and everything, and then I took in her son by myself because the father died. And I'm the provider of the house. And she don't have a job, she's a full-time mother. And I'm the one that pays for all the bills, all the food, everything.
So here's the thing, it's a second-degree felony. All I know is what you're charged with is serious, and I cannot feel comfortable without more information or some type of hearing. Now, if you want to go hire a lawyer and they can file something to come in and have a hearing where everybody has notice of it, the district attorney can put on any evidence. If she wants to show up, she can. Then we'll discuss it at that point. But the only way to get that done is going to be probably to get, let me see, who's his court appointed? Who's his court appointed? I got it.
I believe it's,
Mr. Parker? Mr. Parker was appointed to represent you while you were in custody. He is still your court-appointed attorney. Talk to him about all of these issues. He can file something, we can have a hearing, have her here, and then I will consider lifting that no contact. As of now, it's a no contact. So,
so Pastor, he can do it, Pastor, we can,
well,
just trying to go.
nothing's going, listen. You see how many people are in here today? I have that many people every day. I understand you've got a lot of issues. I'm trying to help you out. Talk to Mr. Parker. You have a no contact as of now, period. Step in front of the clerk, she'll give you a reset notice. In cause number 25 DCCR 1362, that is the aggravated assault with a deadly weapon. And if there was not already a condition of your bond that you not have contact with the complaining witness, which I believe there probably was, then I am imposing that condition now. I understand she's out there. Y'all need to figure out different places to live, different things to do until your case is resolved. Do you understand? That means no contact in person. It also means no communication. If she wants to discuss with the assistant district attorney or the district attorney an affidavit of non-prosecution or things like that, she needs to do that separate of you. You need to still go get an attorney.
So, she already did talk to the district.
Okay.
January the 8th, she starts the class.
She's going through the options class. Okay.
And that's why she told me that this court date was supposed to be.
Well, nothing gets dismissed until she completes that class. Okay, and so what they do is she goes through that class. If she still feels that that is what she wants to do, she will let them know that, and then that happens after the class.
Okay, so, I'm here in front of you, I had a good job, and with this case pending.
Okay, the case is, there's nothing I can do about the case pending. So your case is pending until it's resolved one way or the other. If that's, I understand, and it's also the time of the year where things go a little slower, like the options class isn't being offered till January and things like that. None of that changes what I'm going to set as your bond condition, which is the no contact order with her, okay? You need to, I'm gonna reset your case to give you some time to see if you can get someone hired. If you get a lawyer hired before the next court date, bring the reset notice that you get today, they'll tell you what to do. If you're unable to hire someone, you need to talk to at least 3 lawyers and then bring me who you're talking to and we'll discuss your options. And then it might just take a couple of resets of this. If she goes through that class and the case gets dismissed, then you may or may not really need one, but I want you to be working on it just in case.
So, I asked, if I did hire one, and it does get dismissed, all of them.
That's between, well, and so I typically wouldn't say that this, Ms. Malfino, do you guys have a way to check and confirm that someone has at least signed up for an options class in January?
Yes, ma'am. What's the
It's,
name?
what's her name?
Patricia Zamora.
Patricia Zamora on a January 8th. If you'll just double check that for me. Okay, have a seat again. Okay.
And it's in the bond conditions that there was no contact with her name.
Okay.
It says it in the
Just
thing,
saying,
so.
well, okay, I'm gonna hold on to this for a second. Okay, so the test was negative. Mr. Ibarbo, you wanted to say something, sir?
You could address the court.
Yes, sir, I'm just, the honor system, probably an alcoholic drug addict my whole life. I went through treatment. I reached a point when this case came about, that, everything, my whole life, the futility of it all was overwhelming. And, anyway, so I've been cleaning souls since July the 8th. I go to AA regularly. I like it. It's where I belong. I've got a sponsor today. I'm walking the steps. I'm just on step 4. It was where I found a purpose that I've never had. And I think I could do well on probation. And, hopefully one day save somebody else from living another day, you know what I've lived. Which is horrible addiction. Now that's all I've got.
Thank you, sir. Mr. Coleman?
Judge, I'll be brief. I think the PSI speaks for itself. As
far as criminal history. I would like to add, I have judgments here. I've made them available to Mr. Kimler for additional convictions that were either not included in the PSI or they could not confirm those. And for the record, Judge, I am speaking of a 2013 aggravated assault out of St. Charles, Louisiana, in which the defendant received a 6-month probation. Also, a 2008 possession of a controlled substance case out of Kansas, in which the defendant was revoked to 20 months. In a 2013 fleeing or attempting to elude out of Kansas, for which the defendant received 5 days. I think that one is actually reflected in the PSI,
Okay,
the 5-day one.
yes.
And also, Judge, I have judgments out of Spokane, Washington for 1, 2, 3 thefts. One from 2011, 2 of them, it looks like it was a concurrent 1-year probation in 2008, and also a 2008 assault out of Spokane, Washington, in which the defendant received 338 days. And I've marked them, I'm happy to offer them.
No objection.
I don't know that I need them. I've made the notes and we'll take that into consideration as
Judge, that's all
well.
I have. I think the defendant, given his criminal history, at the risk of sounding callous, Judge, I get it. People are struggle with drug addiction all the time. But at a certain point, Judge, there comes a point where the consideration needs to be protecting the public. This defendant's been having contact with law enforcement since 1988, and he has spanned at least 3 different states with his criminal behavior. Judge, he's fortunate to have a cap of 10. He's exposed to 20 years, Judge. I'm asking the court to sentence him to the 10 years.
4 different.
Guilty of all that. I'm sorry.
Texas, Louisiana,
You all right?
Kansas, and Washington.
I'm very sorry. I think I take probation.
I'm s- Arkansas,
6 or 5.
Alabama,
6.
I guess my biggest issue, Mr. Ebarbo, is, well, one of the biggest issues is I appreciate and I'm glad that you have done what you've done over the last few months. I think you probably started off doing that for the wrong reason, and that's because you got caught again and you're looking at 20 years in prison. It sounds like maybe you're doing better, and that's great. I just wonder why it's taken so long. It looks like you went to the Unity House back in 1986, and other than that, it's just, at some point, you've got to take responsibility before you commit an offense, not after. I've counted 24 misdemeanors. I think with some of the ones that Mr. Coleman has said, there's probably actually more than that. There were some records that couldn't be found from different states. They're probably looking at more like 30. 7 felony convictions. You've been to prison. It's just too much. And at some point there has to be an end to what you're doing and get that help before you continue what you're doing. I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 24, DCCR 1722, find sufficient evidence to find you guilty, and at this time find you guilty of theft, find your prior enhancement convictions true, sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Clause number 24, DCCR 2289, also find sufficient evidence to find you guilty, and at this time find you guilty of theft and find those prior enhancements true. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will run concurrently, which means together at the same time. I've handed you the trial court certification in each of those cases that shows that these were agreements that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. Good luck to you, sir. Thank you. Thank you, Mr. Kimler, Mr. Coleman. Thank you. Morning, Mr. Lane. I need your client to sign that, please. And are we going just on the counts for the DWI, or are we going on?
Just count one.
Just from the DWI, Your Honor.
Good morning, sir. Are you Dustin Drake?
Yes, ma'am.
And Mr. Lane, will your client waive the formal reading of the indictment?
Yes, Your Honor.
And Mr. Drake, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of driving while intoxicated, third or more, from July 22nd of 2024. It alleges that you were previously convicted of driving while intoxicated February 8th of 2012, and then again January 22nd of 2021, and June 22nd of 2022. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? And are those prior convictions all true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lane?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And so there's no agreement, is that correct?
It's essentially a 10-year cap, Your Honor.
So the agreement is not to go
Pleading open
forward
to third
on,
degree.
okay. So it is a plea bargain because, and there is a waiver of right to appeal because the prior offenses are waived, correct?
Correct.
And I did waiver, but we could do also plea bargain if the court wants.
No, this is fine the way it is. It shows that you did the waiver. I just want to make sure. I'm going to, just to make sure it's all clear as part of that plea bargain, if with their, well, on the unagreed page, I'm just going to write in with everyone's permission that part of the agreement was to go on just count 1 and not the prior others. That would make it a second degree.
Third degree.
Well, his prior felonies would make it a second, so that's what the plea agreement is, to go on count 1 only.
Oh, okay.
So I just want to make sure that that's on paperwork somewhere that shows that there was an agreement for something, and that's why he waived right to appeal.
Yes, sir.
Okay.
Fine with me, Your Honor. Thank you.
No, it's included as a lesser included. It's not.
Okay, and so there's no agreement with regard to, other than the fact that they're going on count 1 only. And so in effect, that means that it is up to me to sentence you in the range of punishment for that third degree felony, which is between 2 years and 10 years, you understand? And as long as I do that, then you'll be waiving or giving up any right to appeal. Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? And I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first would be to determine if you're guilty or not, and then if they find you guilty, you could leave your punishment up to them. By going forward this way, you're waiving that and leaving it up to me, and is that what you want to do? All right, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Drake is not competent?
No.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Lane. He will present it to me on your behalf when we come back. On your way out of the courtroom today, you need to stop and talk to the probation department, and she's sitting at that desk right back there. Okay? Thank
Your
you.
Honor, I
Is
was
that
just going
mine?
to- Well, I was just going to ask if we could get, he has a full hip replacement Monday, and I think it's going to be about a 6-week recovery.
We're at least 6 weeks out, so if you want to do it January 26th,
That's
so,
okay. Thank you.
okay, thank you. All right, be sure you stop and talk to probation.
Judge, with the court's permission, we're gonna plead this to a lesser included. He has, over the recent months, provided ample documentation of his attendance in rehab and portable
Okay, thank you.
results.
All right, so are you Guillermo Galvin?
Yes, Your Honor.
And Mr. Crenshaw, will your client waive the formal reading of the indictment?
We do, Your Honor.
Let me get that pulled up. I'll take it. I'll take it. I keep pulling it up the wrong way. So paragraphs 1 and 2 then, to make it a Class A. Okay. Mr. Galvin, in cause number 24, DCCR 2321, the state's elected to proceed on paragraphs 1 and 2 only. Paragraph 1 alleges the offense that we're here for today, that you committed the offense of driving while intoxicated September 28th of 2024. Paragraph 2 alleges that you were previously convicted of driving while intoxicated April 30th of 2014. And how do you plead to that charge?
Yes.
And is that prior conviction true?
Yes.
Did you enter your plea of guilty and true freely and voluntarily? And because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Crenshaw? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for, is it a 1-year term, I guess?
Yes, Your Honor.
With everyone's permission, I'll mark that through, put that on here.
Please, thank you.
So it looks like the agreement that you've reached is for a 1-year term in the Jefferson County Correctional Facility, but that would be probated. You'd be on probation for 2 years. You would be ordered to pay a $4,000 fine, serve 1 weekend in jail, and follow all of the other rules and conditions of probation, also including having the auto ignition interlock device and a portable breath device. Is that your understanding?
Yes, Your Honor.
Are both necessary while on probation, or can we just do interlock?
We just need one.
Yeah.
Yeah.
He's done well on the portable. I'm fine with just the interlock, whatever.
I think the interlock is what I would prefer to have. All right, with everyone's permission, I'll mark through that on the paperwork.
Thank you.
So you would be required to have the auto ignition interlock device on any vehicle that you drive. Do you understand? And are you a U.S. citizen?
Yes, Your Honor.
State tenders number 1.
No objection?
It's admitted any evidence that Mr. Galvin's not competent.
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated. Second, sentence you in accordance with your agreement to a term of 1 year in the Jefferson County Correctional Facility, but I will probate that. You'll be on probation for 2 years. You're ordered to pay the $4,000 fine and to follow all of the rules and conditions of probation, including having the auto ignition interlock device on your vehicle. You will serve 1 weekend in jail. That will be the weekend beginning November the 28th. You'll be required to show up at the jail at 6:00 p.m. Don't be late, don't show up under the influence of anything. Both of those things could be violations of your probation, and you'll be right back in here. Do you understand? If you do everything you're supposed to while you're on this probation, then for all practical purposes, your case here in court is over, and you'll be able to serve that term while you're out on probation. The other side of that, however, is if you violate any condition of probation, you could be brought back in, and you would be facing that 1-year sentence that you've already agreed to. Do you understand? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation, she's sitting at that desk right there. She will call you up when she's ready to go over your paperwork. All right, good luck to you, sir.
Good morning, Your Honor.
Good morning, how are you?
Doing well, thank you. Good seeing you.
You too.
Let me see this one.
And let's see, or is going just on the DWI?
Yes, Your Honor.
Okay. I'll take it. You'll just, that's all right, if you'll just email, make sure you get that emailed,
It should be
the attachment.
Sarah's email.
Okay. Good morning, ma'am. Are you Catherine Castillo?
Yes, ma'am.
And Mr. Pageant, will your client waive the formal reading of the indictment?
Yes, Your Honor.
Ms. Castillo, in cause number 24, DCCR 2458, you're charged with a third-degree felony offense of driving while intoxicated, third or more, from October 10th of 2024. The indictment alleges you were previously convicted of driving while intoxicated April 11th of 2013, and then again April 22nd of 2015. And how do you plead to that charge? And are those prior convictions true?
Yes.
Did you enter your plea of guilty freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Paget?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and follow all of the rules and conditions of probation, and that includes that 10-day mandatory upfront time. You understand?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objections to states one, Your Honor.
And also, it's admitted, also as a part of this agreement, the state is going to dismiss cause number 24, DCCR 2457, correct?
And there's a misdemeanor case as well.
Okay, and also the misdemeanor case.
Yes, Your Honor.
Is there any evidence that Ms. Castillo is not competent?
None, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we will come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. Okay? We'll see
Thank
y'all
you,
back
Your
at
Honor. May I be
sentencing.
excused?
Yes, sir. Thank you. Good morning. You're Brian Battle.
Good morning, ma'am.
And Mr. Battle, did you get someone hired?
I've filled out the paperwork, I like that.
I'm sorry?
You told me to reach out to 3.
Right.
Yes.
Were you able to get anyone hired?
I know, ma'am.
Who'd you talk to?
I talked to, James R. Neckin, PC, the attorney at law. I talked to Benjamin Jeffries, the Hurts Kelly law firm. And then I also talked to the law office of Brittany A. Holmes.
Okay, so where, do you think you're gonna be able to get anyone hired?
Possibly.
Are you working?
Yes, ma'am.
Where you work?
I work at Checkers.
Okay, so thank you for doing what I asked you to. I'm gonna have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. Be sure you fill it out accurately and completely, because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. If you step in front of the clerk down there, or is it pro se? It should say on the front of the folder. Good morning, are you Trinity Bell? Yes, ma'am. And Ms. Bell, this is your initial appearance in cause number 25, DCCR 1381. Sorry, my computer's going slow. Is it? You're charged with the second-degree felony offense of assault of a peace officer, and that's from September 5th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer? All right, so what I'm going to do, Ms. Bell, is reset your case for about 30 days to give you some time to see if you can get someone hired. If you get a lawyer hired before the next court date, bring the reset notice that you get today to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you step in front of the clerk, she'll give you your reset notice. Good morning. Are you Larry Bigelow?
Yes, ma'am.
And Mr. Bigelow, this is your initial appearance in cause number 25 DCCR 1333. You're charged with a state jail felony offense of solicitation of prostitution from March 28th of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I had talked to one and I'm making, payments on it.
Okay, who's that?
I forgot his name. I forgot his name.
How will you know to who to go make payments to?
So my wife make payments to him.
Okay, so what I'm gonna do, Mr. Bigelow, is reset your case about 30 days to give you some more time to get that person hired or someone hired. Bring the reset notice that you get today to that lawyer and they'll tell you what to do if you do get them hired. If for some reason it's not gonna work out with that lawyer, then make sure, I want you to visit with at least 3 other lawyers. Bring me back those names so I know you're trying, and then we'll discuss your options. Also, if you've made payments and you haven't been able to hire that person in full, bring me receipts of those payments, okay? Step in front of the clerk, she'll give you your reset notice. Good morning, ma'am. You're Lacaria Kirkwood? And Ms. Kirkwood, did you get someone hired?
No,
Who'd you talk to?
Mr. Eric Franklin, attorney at law, Mr. Benjamin Jeffries, attorney at law, and Mr. Ryan Curtis, board certified criminal lawyer.
All right, and so,
And Mr. Price.
okay, well, good. Thank you for doing that. So where are you, do you think I'll be able to get someone hired? Are you working?
Yes, ma'am.
Where do you work?
I do home care, accent care.
Do you do that for a company?
Yes, ma'am. Accent.
Accent?
Yes, ma'am.
All right, so I'm gonna quit chewing gum. I'm going to have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to fill it out accurately and completely because you're gonna swear under oath that it's all true and correct, and then I'll take a look at it. If you step in front of the clerk, she'll give you that. Good morning, you're Justin Payne? Mr. Payne, sweatpants are not appropriate for court. You need to wear something nicer next time, okay? They're jeans? Okay, thanks. So this is your initial appearance in cause number 25 DCCR 1358. You're charged with the second-degree felony offense of aggravated assault with a deadly weapon, and that is from September 5th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yeah, I had talked to a couple of lawyers, I had been, I had surgery on one of my kidneys, so I haven't really made it pay me yet. I've been going to dialysis, but I'm going to find one at home.
Okay, do you think you're gonna be able to get someone hired? Are you working?
Oh, I'll get Social Security.
You do? So if you do, I mean, you would be eligible for a court appointed if you would like, or if you want to hire your own lawyer, I'll give you some time to do that.
I'm going to have my own lawyer.
Okay, so I will reset your case about 30 days to give you some time to get that done. If you find someone that you hire, be sure and bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're not going to be able to, then when you come back, bring any documentation, Social Security, medical issues or things like that, and then we'll take a look at it, okay? Step in front of the clerk, she'll give you your reset. Good morning, ma'am. You're Maria Garza?
Yes.
And did you get someone hired, Miss Garza?
No, ma'am.
Did you talk to some lawyers?
Yes, I spoke to James Porter, William Marcus, and Gregory Jackson.
Okay. And so where are you on being able to get someone hired, do you think? Are you working?
Yes,
Where do you work?
I'm self-employed.
Doing what?
Food,
What?
food,
Food?
food, yes.
Okay. What do you mean food?
Amanda is more
Okay,
like topics.
okay. So, is that full-time?
Not right now.
Okay, so you probably need to get out and get some work so that you can pay an attorney, okay? You understand?
Yes.
Okay, so I'm gonna reset your case one more time. You need to try to get someone hired before the next court date, or at least talk to 3 others. And also, I want you to bring me some proof of any kind of documentation of what your income is, what you've done to try to make more income, okay? All right, step in front of the clerk, she'll give you that reset. Good morning, give me just a second, sir. You are John Tat Taylor?
Yes, ma'am.
And Mr. Taylor, it's very important that you are on time to court, okay?
Yes, ma'am.
Going to recall the bond forfeiture. Let me find it here.
Yes, I live out of Fort Worth, and I called and told them I was on my way, but I was traffic.
Okay, that's fine. So this is your initial appearance, Mr. Taylor, in cause number 25, DCCR 1427. You're charged with the state jail felony offense of fraudulent use or possession of credit or debit cards, and that's from July 17th of 2025. Your indictment alleges a couple of prior offenses. Since you have made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am.
So what I'm going to do, Mr. Taylor, is reset your case for about 30 days or so to give you some time to try to get a lawyer hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what you need to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? Step in front of the clerk and she'll give you your reset notice, please. Good morning, sir. You're Dontrell Scott?
Yes, ma'am.
And this is 25 DCCR 0504. Mr. Scott's charged with official oppression, and what is the announcement?
Judge, the state and I have been discussing this in depth. I'm going to be applying for a pretrial conversion for Mr. Scott.
Okay,
And so we can get that done. I've got to get obviously some package material together for him. And then I'll be writing that letter and make an application.
so let's do maybe 45, 60-ish since we've got the holidays. If you'll get that filed quickly, I know that'll
I will, Your Honor.
take them a little bit also with the different things coming up. Mr. Scott, any issues, Mr. Smith? Mr. Scott, stay in touch with Mr. Johnson. He'll let you know when you need to be back.
Yes, ma'am.
Thank you. You're free to go. Thank you, Mr.
Good to see you,
Johnson.
Judge. Thank you.
You too. And that's for pretrial diversion request. Good morning.
Judge, actually, I forgot there's a new case. We need to sign up for the new case as well.
Oh,
I
okay.
thought it was just most of the open.
Okay, I don't see anything yet anyway. I'll hold them all.
Okay, I'm sorry. miss.
Go have a seat, ma'am. The motion to,
Dismiss, Your Honor.
okay. Boy, everybody's getting they're
There's
lining them up today.
You got like three coming from me today.
I see. All right, so
And
you're
Judge, I'll just
Elijah
put on
Riley?
record while we're here, last time we were in court, I received a sworn statement from an eyewitness to this incident that refuted what was essentially the official narrative of what happened. Without that testimony, the state cannot prove any of the elements of this case. That's why I'm dismissing.
All right, I will sign that dismissal. Mr. Riley, I'm signing a dismissal in your case. Obviously, something went on. You need to stay away from anything and everything that's going to get you back in here, okay?
That was my house.
You're free to go. You're free to go. Mr. Spites, in cause number 25 DCCR 0023, you're charged with a 3rd-degree felony offense of theft of property from September 14th of 2024. The indictment alleges you were previously convicted of felon in possession of a weapon, a 3rd-degree felony, May 18th of 2023. And how do you plead to that charge? Speak up. And is that prior conviction true? Did you enter your plea of guilty freely and voluntarily? And did you plead guilty because you actually did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Ms. Hawkins? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 5-year deferred probation, $500 fine, and there would be restitution that would be determined between now and when we came back for sentencing. Is that your understanding? Do you also understand that if you're not a U.S. citizen, a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Spites is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right, thank you. See y'all back at sentencing. Ms. Holmes, I signed the dismissal in Ms. Renfro's case and told her she could go.
Yes, ma'am, I saw her, thank you.
Thank you. Good morning. Are you Hillary Lawrence? And Ms. Lawrence was previously in court on cause number 25 DCCR 0296. Entered a plea of guilty to the state jail felony offense of theft of service. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir, I have.
Are there any additions or corrections?
Not from the state judge.
And so the car is still missing, so restitution would be the 25,000?
As best I can tell, Judge, honestly, the ABIS doesn't do a very good job of tracking these things.
Well, it's hard to
I know.
feel comfortable ordering that much restitution if the car. Ms. Lawrence, you don't have any idea, do you, if the car ever got returned or what happened to the car?
I'm ready to, if I remember, and that person's in jail, so I don't know what happened.
Oh, okay.
Judge, I'll just note for the record, probation attempted multiple times to get a
That's what I'm
confirmation of the
seeing.
whereabouts from ABIS, and they weren't helpful.
Okay, then I'm not gonna order it.
Fine with
Okay.
me, Your Honor.
Okay, thank you, Mr. Nichols. All right, I'm going to, any reason not to go forward?
No, Your Honor.
Ms. Lawrence, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. Because there's not restitution, I am going to order a fine of $500 and order that you follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you do not have a felony conviction on your record. And if you complete the probation, at the end, the case is actually dismissed. You'll never have a felony conviction. In fact, if you do everything correctly and get things done up front, community service and things like that, I sign early terminations for probation all the time. You may not even have to do that 5 years, but that's going to be up to you to get it done properly and the way it's supposed to. If you don't do that and you violate the condition of probation in any way, you can be brought back into court, found guilty of the offense, which means you would be a convicted felon, and you could go to the state jail prison for up to 2 years. Do you understand? All right, I'm handing you the trial court certification. This shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. All right, good luck to you, ma'am. Stephen Boudwin, sentencing. Good morning. Are you Stephen Boudwin? Yes, ma'am. And Mr. Boudwin was previously in court, entered a plea of guilty to the third-degree felony offense of lesser included offense of attempted robbery. I've received the pre-sentence report. Has everyone had an opportunity to review the report? Are there additions or corrections?
Judge, I just would like to state for the record, for the court's recollection, that in this case, the complainant via her mother called the court several times, called me several times, came up to the office several times, expressing her fear of the defendant, to which the court agreed to increase his bond, to which she then bonded her out. So that's all I wanted to add on that.
Okay. All right, then I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent, understood that plea. Going to find sufficient evidence to find you guilty. However, I'm going to follow the agreement and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $250 fine and to follow all of the rules and conditions of probation. It is a condition of your probation that you have no contact or communication with Janiyah Lewis. We've gone through this. She cannot give you permission at this point to violate that condition that I've placed on your probation. So whatever the relationship is, at this point, it's over. If there's some options later, you talk to your probation officer and you guys are trying to work things out, there's certain ways you can do that appropriately and through probation. And then I would consider lifting that no contact, but not until then. So she can't say it's okay, come over, because then if something happens, y'all get in an argument, she calls, you're going to prison, not her. You understand? All right, so if you do everything you're supposed to on this probation, it's an excellent opportunity because you don't have the felony conviction on your record. At the end of the probation period, if you successfully complete it, the case is actually dismissed. You'll never have the felony conviction. The other side of that is if you violate any condition of probation, you can be brought back into court, you could be found guilty, and you could be sentenced anywhere in the range of punishment, which is up to 10 years. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation will call you up when she's ready to go over your paperwork. Good luck to you, sir. Ms. Talmore, in cause number 25, DCCR 0595, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from April 4th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they've charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State Tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Talmore is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's sitting at that desk right there. All right, we'll see you back at sentencing.
My little Aggie.
I know, I saw it. I love when they get that just full face. This is Mr. Hoffpowers. Castaneda. Good morning, sir. You're Timoteo Castaneda?
Yes, Mom.
And Mr. Castaneda, in cause number 25, DCCR 0360, is charged with indecency with a child by sexual contact. Mr. Crenshaw.
Judge, we're still, I'm working with Mr. Hoffpower to reach a plea resolution. We just haven't been able to do it yet. But if we could come back, please, I believe we'll have a resolution on the next set.
Okay, sounds good. Any issues that you see notated?
No, Your Honor, just plenty of notes about discussions with Mr. Crenshaw.
Mr. Castaneda, if you'll just stay in touch with Mr. Crenshaw so that you guys can visit before that next court date, and then we'll see you back then, okay? You're free to go. And I'll hold the other two while you do that paperwork. Good morning, you're near Benur?
Yes, ma'am.
And Mr. Benur's case is set for trial this